Special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The reddyesq.com site provides you with the latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the February Visa Bulletin and H1-B registration, how to avoid H1-B RFEs. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hi, Ms. Reddy, how are you doing?
Hi, Tony. I'm good. How are you?
Very well, thank you. So, Ms. Reddy, you promised all of our viewers to continue the session from last week, and you're keeping your promise, which is great. So, before we get into the topic, would you want to discuss any latest updates, Ms. Reddy?
Yes, so we should. We have to discuss the February Visa Bulletin since it just came out.
Right.
I think that's a good topic to discuss. And there are a lot of our viewers that, look at the Visa Bulletin every month. There are thousands of people that have 485 either pending or have I-140 approvals and are eagerly awaiting for their visa number to become available. Before we discuss the Visa Bulletin, I just wanted to give our viewers some background on what the Visa Bulletin is and why it's important.
Right.
So every year, USCIS issues, or the Department of State actually, issues a certain number of green cards. The green cards that are issued are limited. And out of the total green cards issued, every country gets about 7% of that total green card numbers, no matter what the population of that country is. So to put things in perspective, a huge country with a huge population like India gets the same as, a country like Iceland, which has a very small population. So what has happened is that it's created an imbalance whereby people, Indian nationals are waiting for years and years, 10 years, 20 years to get their green card, while people from other countries get their green card faster because that 7% cap numbers that they're getting are enough for them. So that's why there's this disparity created between the worldwide and countries such as China and India. So having said that, just going into who can file their green card and when. So you could, you have to first file, in some situations, you have to file a labor cert. In some situations, if it's employment-based, you have to file an I-140. If it's a family-based case, you simply file your family-based immigrant petition, which is an I-130. And so the date when you file that immigrant petition or the date that you file the labor cert, where labor cert is needed, is your priority date. So that's fixed. Your priority date never changes. So once you have covered the first two steps or the first step, depending on what type of green card you're filing, in order to file adjustment of status or a 485, your visa numbers or green card numbers need to be available for you. And how do you know whether it's available or not in order to file your final step, which is the 485? You look at what's called a Visa Bulletin, which is published by the Department of State every month, usually in around the 15th of the month, sometimes earlier. So when you look at this Visa Bulletin, you will see two tables. One is dates for filing, and the other one is the final action dates. Now, and you'll also see dates for employment-based cases and dates for family-based cases. So depending on what type of case you have to go to that particular table. And in order to decide whether to go to look at the dates for filing to file your case or the final action date, you have to go to the USCIS website, which there's a link of that available within the Visa Bulletin page. And that USCIS will tell you which table to follow. The dates for filing, which is an advance date provided by USCIS because they think that your case will soon become current. So they want to take your case and start processing it. And they hope that by the time that the case is processed, your date will actually become current. So they're taking the case in advance. That's the date for filing chart. The final action date is your actual date that your numbers will become current. So if that date has reached or is beyond that date, then that means you can file your green card. That means your dates are available. That means there are enough numbers in order to file your particular case. So this month, USCIS has said that they're going to follow dates for filing. Sometimes that makes a huge difference because there is a big difference sometimes between the dates for filing and the final action date. So for people who've been waiting in line, they at least get to file a 485, even though they won't get a green card because they have to wait for the final action date to get a green card. But at least they get the benefits of filing a 485, which is advance parole, flexibility in employment, meaning having the chance to transfer employers easily, not having to maintain your H1-B status or L1 status, being able to travel on advance parole, not having to go for a visa every time your visa expires. So these are the advantages in having a 485. So coming to now February visa bulletin, there is actually not much change, which is good news and bad news. The good news is that it's not further retrogress, so that's good news. The bad news is that it hasn't advanced either, and if it's going to continue like this is not good news for for this year because as we know that in December all the dates retrogressed. So now looking at dates for filing, since that's the month, that's what they're looking at this month. For India, it's June 1. For EB1 category, it's June 1, 2022. So this retrogressed, EB1 retrogressed last month. Before that, it was current for a long time. Now it's retrogressed for dates for filing to June 1, 2022. So retrogressed by more than 6 months. EB2 is May 1. Then that we know has retrogressed already. And EB3 is August 1. So as we have seen, the dates have retrogressed significantly. So looking into the final action dates, which is usually the dates that we look at, we don't usually look at the dates for filing because these are the dates that will actually determine when you get your green card. So EB1 China and India both remain the same with a cutoff date of February 1, 2022. So slightly better than June 2022 for the slightly worse than June 2022, which is the dates for filing. Employment-based second category, no movement in EB2 for China as well as India. For EB2, India remains at October 8, 2011. And EB3, India, again, no movement from last month. It remains at June 15th, 2012. And the cutoff date for China, EB3, is August 1, 2018. So not much difference between the final action dates and the dates for filing. As you can see, they're pretty much very close to each other. So, for all practical purposes, we like to concentrate on the final action dates. So that's basically the rundown for the visa bulletin for January. Now we can go into the actual topic.
Right. So, Ms. Reddy, going into the actual topic, I think we were discussing about the H1-B registration process. And we have the February visa bulletin and the RFEs regarding, H1-B as well. Which would you want to start off with?
We can continue with the registration questions, and then we can.
Right. So, Ms. Reddy, we have some questions that were still left over from last topic, and we have a whole lot of new questions for today's topic as well. So, I'm going to start over with the first question. It says, from the continuation of H1-B registration process, may an authorized signatory within the company who is different from the authorized signatory that signed the H1-B electronic registration sign the form I-129? Is that possible, Ms. Reddy?
Yes. So just to give for those people who missed last week's episode, we talked about H1-B registration, how to register online, what processes to follow, the do's and don'ts. And also we touched upon some frequently asked questions. So as a continuation of that, the question being, does the same person signing on the registration have to sign on the H1B? Absolutely not. Doesn't have to be the same person. As long as it's an authorized signature of the company, a HR or owner of the company and such who signs these kind of documents, they can sign the H1B petition. It doesn't have to be the same person.
Right. And Ms. Reddy, how will, going on to the next question, how will USCIS handle successor interest in interest issues for H1B cap registrations? For example, when a company A submits a registration which gets selected, but then is purchased by company B before the H1B cap petition is filed for the selected registration. How can one handle that situation?
So in that situation, it is a successor in interest, and in many instances, the successor in interest formula is used. So basically, if as the example says, if company A is bought over by company B, and you have the agreement, the sale or the purchase agreement, which shows that it's the same company, and just the name might have changed, the ownership might have changed, but the company is the same, then there is no issue with the new company then taking over the registration and being able to file the H1B with the new company's name. The only issue in this case is you have to show through documentary evidence that you are a successor in interest.
Right. So then that ends our H1B registration process FAQs. Moving on to H1B RFAs, Ms. Reddy. But before we begin with the questions, could you probably tell our viewers how to, in general, how can they avoid H1B RFAs?
Right. So there's some, this is a big topic by itself, but I wanted to bring to light a few common issues that have to be looked into, that one has to examine before actually filing a H1 to avoid getting an RFE. So the first one that to keep in mind, and the most basic, is whether you qualify for the H1 or not. Meaning, does the job qualify for a H1 or not? Another way of putting it is the job a H1B specialty occupation or not? One of the most common reasons for USCIS to send a RFE is the failure to establish that the position qualifies as a specialty occupation. So a specialty occupation is an occupation which requires a bachelor's degree in a particular field. And of course, the beneficiary who is for whom the H1B is being filed should also have that bachelor's degree in that related field. So recently, USCIS has chosen to narrow its interpretation of what qualifies as a specialty occupation, and they often challenge positions with by looking at the job duties, and they say that the job duties don't appear to be complex enough to require a bachelor's degree or its equivalent. So we always recommend that the first thing you do is identify whether it's a specialty occupation or not. How do you identify this? Many ways of identifying it. One is go directly to the Department of Labor publication, which USCIS refers to as well. It's a publication called Occupational Outlook Handbook, and that's available online. And go and check if your job position exists, what the minimum qualifications they say for that job is. For example, if you go to software engineers, it'll say bachelor's in computer science or related is usually required, and that is sufficient to prove that it's a specialty occupation because there's a bachelor's degree requirement and it's in a specific field. Instead, if suppose you go to some other position, it might say bachelor's in arts is a requirement. So that's not specific, or an MBA or a BA is bachelor's in business administration, BBA is required. So business administration or arts is not considered to be a specific degree, and often USCIS will send an RFE on those kind of cases. So that's one way to identify whether it's a specialty occupation or not. Another way to identify, and USCIS often recommends this, is through the job duties, through the roles and responsibilities. So if you're able to show that the job is complex enough to require a bachelor's degree, even if the OOH doesn't show that it requires a bachelor's degree, you can still get a H1-B approved. So you have to show, really give details of the job description, give details of the complexity of the job description, show, maybe make a table and show how each job description requires a bachelor's level education. So this is a possibility, a way of showing specialty occupation or not. Another way of showing specialty occupation is by proving industry standard. So you can show, for example, in your establishment itself, you have hired people with bachelor's degrees in the past, and you can show W-2s, you can show degree copies of your previous employees that were hired for the same job, for example, for a software engineer job. Or you can show job postings from DICE, from the Department of Labor website itself, from any job website to show that bachelor's in, say, computer science is a minimum requirement for your job. So that's industry standard. That's to show that, most industries require it. So that's another way of showing specialty occupation. You should also make sure that your job, as I said earlier, is linked. You have to provide the link between the job description and the educational requirements for the position. So you can't just say a bachelor's in computer science is required when maybe you're filing H1 for a low-level computer services, like a tester or something like some kind of such position, maybe programmer, computer programmer. Then maybe it might be more difficult to show. That's why you have to show the link between why, the person's computer science degree and the job description. So that's important. A segue into that is for specialty occupation, something that we need to know is the SOC codes. So the SOC codes is the code that is usually in ONET occupation, in the ONET online database, which is also published by the Department of Labor. And that SOC code is required because that's how they identify the jobs. And that's required because you have to put that in the LCA as well. So something to remember to avoid RFEs this year is the SOC codes have changed last year. And a lot of people have not looked at it carefully, maybe from this year to last year. So important to give it a look. One important change has been that some codes that were not previously available. So if the code is not available, there's not much information available on that particular SOC code on ONET. So as I was saying, in order to know whether it's a specialty occupation or not, you can go to Occupational Outlook Handbook, but you can also go to the ONET, which has the SOC codes, has the job description, and would also say whether a bachelor's degree is required or not. So this is an important tool also in addition to the OOH. So when there is no specific code mentioned for a particular job title, you'd have to use all others, computer professionals, all others, or some such code. But there's never details about job description, about what kind of degree is required, how much experience is required. If you go into the all other category, because it's not specified as yet. But so luckily, this year they've added a few codes, so we have much more information, such as software quality assurance analyst has been added, data scientist, which is which has been in the market and a very marketable job, but we didn't have any information on data scientists earlier. Now we do. Software developers, they used to have different codes for software developer applications, software developer systems. So they've made all that into software developers and given it one code, 1252 is the code, for example. So this addition of additional job titles into the ONET has been really helpful. The other change that we see in ONET and the SOC codes is duties of some jobs have changed very subtly, just a few words, but it makes a big difference. as I was saying, duties are important because if you're able to show that the duties are complex, then you can show that the position requires a bachelor's degree. So for example, in the past, we used to often use systems analyst as a specialty occupation, and then we stopped using systems analyst because they were denying those cases because the OH says bachelor's degree in engineering or all others required. So USCIS kept saying that it was not specific enough, the degree requirement, and therefore it's not a specialty occupation. So we switched instead to software developers, which has a much higher prevailing wage. So, I think they were basically forcing people to pay a higher wage. But the interesting thing is that the software systems analyst duties have been changed. And as I told you, there are different ways of showing specialty occupation, right? So the software systems analyst duties have changed from data processing problems to implement and improve computer systems to implement solutions to complex application problems. So this one line, complex application problems, has been added, and this makes a huge difference in whether it's a specialty occupation or not. Because if you use the word complex, it naturally means that the job is more difficult to do, and therefore it's easier to justify that a bachelor's degree is required. In addition to that, often another common reason to get a H1-B RFE and something to avoid is the availability of work. So avoid sending out skeleton petitions. Always make sure that you put in documentation to show that you have work for your employee while you're filing the petition. So availability of work is shown in different ways depending on what kind of industry you're in. If you're in an industry, say if you're an accountant or a lawyer, most probably you'll put in your tax return, or you'll put in a list of your clients, or some information to show that you have a good business, then you have scope to require another lawyer, say, or another accountant. If you're working in an IT consulting firm, you would have to put in a PO, purchase order, or an MSA to show that you actually have a project for this person. You cannot say that, okay, I'm going to hire him first and then look for a project, because USCIS says in these consulting situations that the assignment is then speculative, and they don't allow such H1s to be filed. Additionally, say you are an IT company, and instead of consulting or body shopping, you wish to hire an employee for an in-house project. You have a product and you're developing a product, and you would like to hire them to help design and develop that product, which you will then sell to other companies. Now, there is an issue with this. In general, it shouldn't be a problem, but since it's been misused so often, a lot of companies will just put in a dummy project and say, I have a requirement for 20 people based on this project, and they don't give any information and they don't show any proof that the project actually exists. So what happens then is that the H1 gets denied, or if it gets approved, but if you do this multiple times, they might audit your company and see if you've actually hired all these people for the project, or you've just moved them to a different employer as soon as they came into the US. That has happened also, and they've done audits on those type of companies, and they've had to face fines and criminal charges based on that. So make sure you only do what is true. So it's easy to show what is the truth, and it's difficult to show what is not true, right?
Right.
So if you do have an in-house project, then the documents to be submitted would be something like a project report, which will contain a cost analysis of the project, a sales and marketing analysis. You'd most probably have a usability review report. You'd have contracts and invoices with your clients for that particular product. That's key to show that you already have business.
Right.
You'd have a website, maybe you'd have a patent or a copyright which you've taken for that particular product. So these are some of the documents that you would have if you did have a product. So you would have to submit that, and that's what USCIS usually asks for.
Right. Right. That was actually quite an elaborate information about how to avoid RFEs, and I hope all our viewers were taking notes. But also, Ms. Reddy, moving forward, which is the last topic for our session today, could you probably give our viewers also an H1B outlook? More like
For the cap,
for the cap.
So for the cap, we are thinking or presuming, predicting that the start date will be March 1st, 2023 for the cap to open up, and it might end on March 17, 2023, and the lottery might take place on March 18th, the day after the registration ends, and we'll start getting registration approvals from the 18th to the 31st of March. And then April 1st, as usual, we will be allowed to file our H1-B petition. So April 1st is a fixed date. It always is April 1st. The other dates when the registration will start, when it will stop, could vary a day or two here and there. So we will get more information on the exact dates of when the registration opens up, most probably next month. Also, with reference to the number of registrations, this is a big question. People are predicting, how many registrations are expected this year compared to last year, etc. So I just thought I'll give a quick rundown of what happened in the last 3 years to give you an idea as to what will happen today, this year. So in 2021, we received 274 registrations, and out of that, 124 were picked. So a pretty good pick number, almost 50%. In 2022, 308,000 registrations were received and 131 were selected. So that's like 1/3, right? And then suddenly last year, there was a jump to 483,000. So if you see 274 versus 308, then 308 versus 483, that's quite a jump, almost.
Definitely a surge, right?
Yeah, exactly. And then the pick number was the same, 127,000 compared to 131. So that became like 1/4.
Right.
The number of cases. So we expect that it'll only go higher this year. So expect about 500,000 more registrations, and the pick number will be the same. Has to be the same. So 1 out of 5 cases might get picked. If you're lucky, you'll have a higher percentage of cases picked. But in general, I think that's what to expect. So if you require 5 cases, if you require 1 case, you should file 5 cases.
Wow, so that is the ratio, 1:5 for your probability to increase just for that one chance to get picked out of 5. And let's probably leave on that good note, Ms. Reddy, probably, because that is, I'm hoping that that's a good news. Maybe it's not, but let's pretend that it is. And on that note, Ms. Reddy, we'll have to end the show for this episode, and we're looking forward for another episode of a lot of information from you. Like always, it's a pleasure hosting you, Ms. Reddy. Thank you so much for being on our show.
Thank you, Dorni. Take care.